You know, there is a saying by Benjamin Franklin that says it is better 100 guilty person should escape than one innocent person should suffer. And that applies to South African law. It is a tenet of our justice system that rather a guilty person go free than an innocent person go to jail. And this, in all honesty, is the core principle that a person is presumed innocent until proven guilty beyond a reasonable doubt. And for me, honestly, these delays are important, especially if the court it were to find these 5 accused guilty. For me, it should be beyond reasonable doubt. But let's take a listen to legal analyst Elton Hart.
Start of the SENZO MEYIWA trial and yet another delay. What did you make of this latest development today with the lawyer for accused number 1 saying he's just not ready?
Yes, Marcel, and to the viewers. Obviously, if one looks at it, and then one needs to now respect an accused's right to a fair trial and his fair trial rights as set out in Section 35. But you could see that the judge this morning was very calm in actually addressing the situation with Advocate MNISI to try and establish as to what seems to be the hold-up. And I can see that Mr. MNISI sort of half hinted that if he's pushed and pushed very hard, he would most probably just say, I'm not going to take on this instruction to actually represent accused number 1, and he then needs to find a new legal representative. That, in essence, will then delay the trial inevitably, and it might even make it a longer delay. And here the court is between a rock and a hard place, but you can't also really force the legal representative. If he says he's not ready to proceed with the matter, it means that he's not ready and he might not do justice to the case. So one needs to be very cautious about actually forcing him, but obviously the short postponement, I don't think that we will start on the 22nd of April in any event.
Talk me through this, because the advocate said that he has to review over 40,000 pages. Now, for me as a layperson, 40,000 is many, many pages. In the legal space, Elton, what kind of challenge does that kind of amount, the vastness of that kind of amount of evidence pose to an advocate in how they are expected to prepare?
No, indeed, 40,000 pages, and I was listening to them, and actually Advocate Baloy indicated it could be more like looking at 60,000 pages.
Sure.
And obviously you need to check at the annexes that is also now involved here, because if you read the transcript, it will refer you back to an annex, so you have to go back, check, or they might refer you back to another piece of the record. So while you read maybe at page 35,100, then it refers you to 25,200. Then you must go back to that page and actually go check what was said compared to what is said here, and actually work there. And obviously, when you as a legal practitioner, you do your cross-examination of the witnesses, you have a certain chain of thought in your head. Now, I think Advocate MNISI must come now sort of half. He needs to get into the shoes of the late Advocate MNGOMEZULUs to try and establish what he was trying to achieve with his cross-examination. And a lot of people might say that Advocate MNISI was there while most of these things happened. But if you represent a specific accused, you look at the evidence from a different angle. Now he has to step into the role of Advocate MNGOMEZULUs. Although he has heard everything, he must make sure, is there maybe not some version that I need to put to these witnesses that I felt my colleague most probably left? So it's like we're here in between a rock and a hard place. The court can't press too hard, but you can't also expect the legal practitioner to just go dilly-dally over a person, because this is a person's life at the end of the day.
Especially because we're talking about the cross-examination of Brigadier Bongani Ganinda, who's a very, very key witness, specifically also because he has continued to claim that Kelly Khumalo is the mastermind behind the murder. How important is it that they get this cross-examination right?
Now, this is the make or break of the case. Because if the state can prove that Brigadier Ganinda's evidence is credible and there cannot be a credibility finding against him, the court will accept his version. So the defense must make sure that when they deal with his evidence, they must show to the court that the version he's putting before court is not the only version that's available, and tested and put the defense of the accused to Advocate or to Brigadier Ganinda to make sure that the court won't come out and say, but looking at everything in totality, that he was a credible witness and we should actually believe him. So the state's case here, it's like based on Brigadier Geninda bringing everything together. So the defense must sort of have dig in, and here it's now where you literally have to go in and actually say, yeah, I'm going to break the horse's back to make sure that his evidence is not found to be credible and he's a credible witness, because then you have an uphill battle.
Okay, we're going to leave it there. A rock and a hard place. That's what legal analyst Elton Hart says that court probably finds itself.
And we all know in this case, in especially this court of Judge Rata, that a person is presumed guilty until they prove themselves innocent. So I think Advocate MNISI is trying by all means to do that. He is ethical. He believes in going all out, and he believes in doing a good job. And let's take a listen further to Elton Hart.
The thing is, like, there's not a close list of what you look at. You need to look at what is happening in the trial. And the one thing that stands out is that Advocate MNISI was there involved in the trial from the beginning, from when it started. So he had an opportunity to already cross-examine the witnesses, but he cross-examined the witnesses based on the information that was given to him by accused number 3. So he was working with accused number 3's version, putting certain questions to the state's witnesses and making sure that he covers the basis of accused number 3. And he highlighted that to say that he wasn't paying attention to look at where accused number 1 is implicated in certain things, to say, I'm going to put cross-examination to that. The judge wanted to take him on that route to say, but you did cross-examine all the state's witnesses as if you were like representing. And he said, no, I was doing that in line with my instructions from accused number 3. I cannot now go in based on what I have of accused number 3 and say that it was sufficient for accused number 1, because different things tie different accused to different offenses. So it becomes a little bit complex, and one needs to look at it from that angle and say there cannot be factors, but obviously Section 35 of the Constitution say the accused must be given the benefit of the doubt to get a legal representative. He's entitled to do so. And obviously, I know if the court, if the presiding officer, Judge Rata Mogotleng, is pushing Advocate MNISI too much, he's not going to take up that matter and then say, then he will be asked to be excused as representative for accused number 1. They can find a different legal representative.
Well, let's hear you, Mr.
Well, firstly, my lord, Advocate MNISI has been requesting transcripts of proceedings of certain dates from time to time. So I can confirm he's hard at work as far as the perusal of the record is concerned. My lord, in a long-running matter where one of the defense counsel passes on, I think that inevitably brings along delays, and it will serve no purpose for the state to say we object to the request if counsel says they're not ready. We are mindful of the fact that he was given some time, but if he says he's not ready, my lord, we're not in a position to object to the requests for more time.
Let's hear you, Mr.
Well, firstly, my lord, Advocate MNISI has been requesting transcripts of proceedings of certain dates from time to time. So I can confirm he's hard at work as far as the perusal of the record is concerned. My lord, in a long-running matter where one of the defense counsel passes on, I think that inevitably brings along delays, and it will serve no purpose for the state to say we object to the request if counsel says they're not ready. We are mindful of the fact that he was given some time, but if he says he's not ready, my lord, we're not in a position to object to the requests for more time.
Please think of the system. Let's hear you, Mr. Louis.
Well, firstly, my lord, Advocate MNISI has been requesting transcripts of proceedings of certain dates from time to time. So I can confirm he's hard at work as far as the perusal of the record is concerned. My lord, in a long-running matter where one of the defense counsel passes on, I think that inevitably brings along delays, and it will serve no purpose for the state to say we object to the request if counsel says they're not ready. We are mindful of the fact that he was given some time, but if he says he's not ready, my lord, we're not in a position to object to the requests for more time.